Welcome back to the Constitutional Clarion. This video is provoked by the recent pardoning by the United States President of his own son, along with a large number of other people. It's even been mooted that the incoming President, Donald Trump, will pardon himself. While the United States became a republic in part as a rejection of the oppressive, arbitrary powers of kings, it seems rather peculiar to foreign eyes that United States presidents actually exercise personal powers akin to that of the kings of old, rather than being subject to the kinds of checks and balances that constrain leaders in democratic countries. So the question for today's video is, can Australian politicians, or indeed vice-regal officers, pardon their own child, or a friend, or a political donor, or a supporter, in circumstances where it's done for purely personal reasons? The pardoning power is a prerogative power. Now, this is a rather peculiar type of executive power that was originally a power of kings. And this power to pardon is known as the royal prerogative of mercy. It was originally regarded as an exercise of royal grace. Blackstone traced it back to the times of Edward the Confessor. When King Charles was recently crowned, he was presented with a blunted sword, known as the curtana, which symbolises mercy. And he also held in his hand the sceptre with the dove, which is also known as the rod of equity and mercy. This was intended to indicate that the king's power is to be exercised according to law and tempered with mercy. These royal powers were delegated to vice-regal officers in British colonies, such as Australia, when they were first settled. Prerogative powers existed prior to the common law, but are recognised by the common law, and the limits of these powers can be determined by courts. They continue to exist until such time as they are altered or displaced or terminated by statute. The prerogative of mercy includes pardoning a person by giving them a free pardon or a conditional pardon, or granting them mercy in relation to their sentence, for example, by shortening the sentence or changing its nature, or permitting the early release of a prisoner. The prerogative of mercy was particularly important to Australia's settlement by the British in 1788, as most of the convicts sent to Australia on the First Fleet had been sentenced to death, but had their sentences commuted as an exercise of the prerogative of mercy from death to transportation. On this subject, see my earlier video on one of these condemned prisoners, Henry Cable, which is called Give Me Back My Parcel. It's a fascinating story about how a prisoner who had been condemned to death still managed to sue the authorities, the captain of one of the ships on the First Fleet, for a parcel of his that went missing. The Governor of the Penal Colony of New South Wales was also given full power to grant any offender a pardon subject to any royal instructions. Now, this was used as an incentive for rehabilitation in the colony. The royal instructions did, however, provide for some oversight of the exercise of that power and also required the recording of its justification. For example, the royal instructions of 1879 provided in paragraph 12 that whenever an offender was condemned to death, the governor had to ask the presiding judge for a written report on the case to be put at the next Executive Council meeting, and could also summon the judge to attend the meeting and produce his notes. In deciding whether to pardon or reprieve any offender, the governor was required to consider the advice of the Executive Council, but to make the decision, quote, according to his own deliberate judgment, whether the members of the Executive Council concur therein or otherwise, unquote. The governor was required to enter into the minutes of the Executive Council meeting his reasons. In non-capital punishment cases, however, the early practice was for the governor to deal with all the petitions for mercy without advice from responsible ministers. Now, this led to considerable trouble in New South Wales in the 1870s when a petition was presented to the governor to mitigate the sentence of a notorious bushranger, Frank Gardner. Gardner had been acquitted of the offence of wounding a police officer with the intent to kill him, which was a capital offence. but he was found guilty of 2 non-capital offences. He was sentenced, however, to 32 years of hard labour. Now, it was argued by some that the severity of the sentence showed that it was intended also to punish him for offences that he was suspected of having committed, but for which he had not actually been convicted. Accordingly, there were petitions for his release after he had served 10 years. Now, the matter was subject of fierce debate in the Parliament of New South Wales over 5 days, and a motion opposing Gardner's release was only defeated on the casting vote of the Speaker. The Governor considered petitions for and against releasing Gardner and also consulted with the Chief Justice. The government itself offered no advice to the Governor on the matter, but the Colonial Secretary, now known as a Premier, Henry Parkes, later claimed that he would have advised against the release. The Governor ultimately exercised the prerogative of mercy, releasing Gardner on the condition that he leave the colony. In the ensuing ruckus, the government of Henry Parkes was defeated in February 1875 and replaced by the Robertson government. The British government also became involved, with the Earl of Carnarvon criticising the Governor for not obtaining written ministerial advice before exercising the prerogative and for imposing a condition that Gardner leave the colony. In May 1875, Lord Carnarvon instructed all Australian governors that they should not exercise the prerogative of mercy without having first received formal advice by ministers. In Queensland, however, controversy arose again, this time in 1888, over the case of Benjamin Kitt, who was convicted of stealing 2 pairs of boots. A fairly minor matter, you would think. Now, he was sentenced to 3 years imprisonment. The McIlwraith government recommended that he be released on probation, but the Governor refused, saying that the power was conferred on him alone and not the Executive Council, and that he was concerned that this was an unnecessary interference with the sentence that was imposed by the court. So a sort of a separation of powers type of argument. When the Governor rejected McIlwraith's advice, his government then resigned in protest. When the Governor, Sir Anthony Musgrave, turned then to the opposition leader, Samuel Griffith, to form a government, Griffith, who later became the Chief Justice of the High Court of Australia, declined to form a government. He asserted that from a constitutional point of view, McIlwraith was right. Griffith argued that the Governor should only refuse to follow ministerial advice when imperial matters were involved or the proposed action amounted to an abuse of the prerogative. The Governor then appealed to the British government for support, but it ordered him to release Kitt in the meantime, pending consideration of the constitutional dispute. As no one else could form a government, the government had to go back to McIlwraith and ask him to withdraw his resignation. Perhaps in part due to the stress of the whole situation, the Governor actually died shortly afterwards, before any response had come from London. The British Secretary of State, Lord Knutsford, when he did respond, stressed that the Governor must not act without having received ministerial advice, but that having received it, he was still entitled to decide how to act. While he accepted that the Governor had acted strictly within directions, he said that he would have, quote, exercised a sounder judgment if he had subordinated his personal opinion to the advice of his ministers, unquote. Lord Knutsford was also critical of the government for taking such an extreme course of action, resigning as a government over such a trivial matter. In short, he thought that everyone had behaved poorly. Federation in 1901 didn't actually make much difference to the prerogative of mercy. Criminal law was largely left to the states, so it remains the state governors who are the ones who are primarily responsible for exercising the prerogative of mercy. There are, however, some criminal offences at the Commonwealth level. They include drug offences and offences concerning national security. So the Governor-General can exercise the pardoning power in relation to convictions for federal offences, acting on the advice of the Commonwealth Attorney-General. The Commonwealth Attorney-General's Department on its website states that the test for the exercise of the prerogative of mercy is that it will only be recommended to the Governor-General if the Attorney-General is satisfied that the convicted person is morally and technically innocent of the offence in respect of which the pardon is sought, and that the offender has no remaining avenue of appeal against his or her conviction, or there are exceptional circumstances justifying the grant of a pardon despite there being a remaining avenue of appeal. One concern about the prerogative of mercy is that it could be used by the executive as a means of undermining sentencing by courts, and this potentially raises a separation of powers and a rule of law issue. An interesting conflict of this kind arose in New Zealand. In 1941, the New Zealand Governor-General, Sir Cyril Newell, initially refused to act on ministerial advice to remit sentences of flogging for 4 prisoners who had assaulted several warders during an escape attempt. Their sentences had been upheld on appeal by a court. The Governor-General asked the Minister for Justice whether there were any mitigating circumstances that would justify a change in the sentence. The Minister admitted that there were not. It was simply the case that the government was opposed, understandably, to the penalty of flogging. The Governor-General objected that if the government opposed a particular type of penalty, then it should take the appropriate course, which was to legislate to remove that type of penalty from the statute book. He considered that advising the Governor-General regularly to alter sentences undermined the rule of law and the authority of the courts. Now, after some conflict between both the government and the Governor-General on this point, the government eventually capitulated and agreed to legislate. Upon that point, the Governor-General then signed the order for remission of the penalty. These days, the prerogative of mercy is rarely exercised in Australia, as there are other statutory methods available to review convictions where there is a risk that there has been a miscarriage of justice. In New South Wales, for example, Part 7 of the Crimes, Appeal and Review Act 2001 deals with the review of convictions and sentences. It provides that when a governor receives a petition for a pardon or the review of a sentence, the governor may direct that an inquiry be conducted by a judicial officer into the conviction or sentence, or the Attorney-General may refer the case to the Court of Criminal Appeal to be dealt with as an appeal, or the Attorney-General may request the Court of Criminal Appeal to give an opinion on any point arising in the case. But such action may only be taken by the Governor or the Attorney-General if it appears that there is doubt or question as to the convicted person's guilt, or any mitigating circumstances in the case, or any part of the evidence in the case. It cannot be done just because someone is a relative, a friend, a political donor, or an ally. The prerogative of mercy is, however, still preserved, despite these statutory remedies. It's still preserved by Section 114 of that Act, and it may be used when the statutory routes are not appropriate. In New South Wales, which now happily releases some information about applications for mercy, it appears that most of the applications fail. Between 2018 and 2023, which are the last online available statistics, 56 applications for mercy failed and only 7 applications succeeded. In practice, petitions for mercy are sent to the Governor, who then refers them to the Attorney-General. Departmental officers then assess and advise on the petition. Where a petitioner has other legal options, such as appeals or statutory review rights, he or she must pursue them first. If all those routes have been exhausted, however, the petition is considered and the Attorney-General then advises the New South Wales Governor through the Executive Council on how to respond to the petition. There's a particular reason in New South Wales for the use of the Executive Council. In 1987, in New South Wales, the former Minister for Corrective Services, Rex Jackson, was convicted of taking corrupt payments to show favour to certain offenders by recommending their early release from prison. As a consequence, the New South Wales Cabinet changed the procedure from the Minister directly advising the Governor on the exercise of the prerogative of mercy to one where advice went through the Executive Council. The purpose of this was to ensure that there was greater oversight by a range of different people, and any advice had to go through a procedure that would potentially pick up and deter corrupt conduct in the future. While the courts will not review the merits of a discretionary exercise of a prerogative power, such as the pardoning power, it's possible that they might review the procedure for exercising that discretion, such as where the decision-making is affected by bias or a failure to apply the rules of natural justice. This has occurred in the United Kingdom, and it's also been approved by the Privy Council. The Federal Court of Australia has noted that the, quote, clear trend of authority is towards some degree of judicial supervision of, at least, the process by which the mercy prerogative is exercised. Any kind of process that was affected by bias, with an Attorney General advising that a pardon be given to a relative or a friend, might well then be the subject of judicial review. Overall, the exercise of the prerogative of mercy in Australia does not involve personal discretion of the Governor or the Governor-General. They are obliged, by convention, to act upon ministerial advice. To the extent that advice to pardon is provided by ministers, it ordinarily occurs as part of a bureaucratic process, often in accordance with policy guidelines or as a result of formal reviews, sometimes by courts, and it's potentially subject to administrative law requirements of procedural fairness. What is fascinating is that this very old power of kings to pardon in accordance with personal discretion is not actually exercised in that way in a country like Australia, which actually does have a king. But it is exercised in that way in the United States, a country that overthrew a king in favour of a president who these days looks and acts more and more like an unbounded king. Thank you once again for watching the Constitutional Clarion. I hope you found that interesting. And as always, I look forward to seeing you next time. Goodbye.